Newberry's live webinar. The first question is, PMI insurance supposed to pay property taxes? The answer to that question is no. PMI insurance does not cover property taxes. Typically when a PMI is taken out, it's to cover any amount of arrearages that would accrue if the homeowner stopped making payments on the mortgage. Primary mortgage insurance really is to protect the lender and the lender's interest when they allow a loan to go out where the borrower is not putting down at least 20%. So the best way to look at it is PMI is something that you pay instead of putting down 20%, but the benefit really goes to the lender if there's ever a default or the insurance has to click in. So thank you for that first question. The next question that we have is about short sale versus foreclosure, and why would someone want to do a short sale rather than a foreclosure? Short sale, oftentimes, if there's only a lender that has a first deed of trust on the property and you're trying to negotiate a short sale, oftentimes you're able to get the short sale to go through without too many problems. Once you have something like PMI or there's a second mortgage, then we run into problems with all of the parties agreeing on the terms of the short sale being approved. In those scenarios, a lot of times homeowners are not able to get a short sale approved because all the different entities that have a stake in the home can't agree on the terms. The other issue is in a short sale, if you do not get a deficiency waiver, the short sale doesn't protect the homeowner with regard to the deficiency between the sale price of the home and the outstanding loan balance. An example would be if you had a $200,000 loan, the house sold at short sale for $100,000, the bank would still be out $100,000 in unpaid debt. Just because they approve the short sale does not mean that they necessarily forgive the $100,000 deficiency. So there's two components to getting a short sale approved and protecting the liability of the borrower. You want to get the short sale approved. That removes the deed of trust on the property, allows the sale. But you also want to get the deficiency waiver from the bank, where they're giving up their right to pursue you for the deficient amount. And the reason that makes a difference, because in a foreclosure, the bank would still have the ability to pursue a deficiency. The difference, though, is in a short sale, they would be pursuing under a breach of contract claim, which would allow them a 6-year statute of limitations in order to pursue. However, at a foreclosure sale, under the one action rule, the lender would only have 6 months to pursue the borrower. So it's a huge difference with regard to the time frame that the lender would have in order to pursue. And it also is a very short window logistically for the bank in order to come up with a lawsuit to file in that 6-month period. So what we have found is that the homeowners really are being sued out of short sale transactions more than they are out of foreclosure transactions when it comes to that first deed of trust. Now the second deed of trust or the second mortgage or a HELOC or anything along those lines that came after you purchased the home, those entities are suing after foreclosure and after short sales when there's no deficiency waiver, because in both of those scenarios they would have a 6-year statute of limitations. When the foreclosure sale happens, the second is a sold out junior lien holder, so they didn't get the benefit of the collateral, so the one action rule doesn't apply to them, and they would still have a breach of contract claim similar to what they would have in a short sale transaction. Okay, next question. What about homeowners insurance and PMI? All right. With regard to homeowners insurance and PMI, homeowners insurance is usually going to be picked up by the bank if you're paying it through escrow. So in an escrow account, if they're paying your property taxes and they're paying your homeowners insurance, then it's just going to show a negative escrow balance. A lot of times people are concerned that if they stop making their payments on their home, or they're unable to make their payments on their home, that the bank will allow the taxes and the insurance to lapse. There's many reasons why the bank would not want to do this. For example, if the taxes were not paid, there could be a sheriff's sale which has a priority on the home, and the bank would definitely not want to have their interest compromised by back taxes, which is usually a very small amount in comparison to the total balance on the home. So the bank is always going to make sure that the taxes and the insurance are paid, so long as they were already paying them prior to the default happening. So if there is an escrow account on the home, the bank will maintain it to ensure that they have clear title if the foreclosure is to go forward. Any foreclosure would require them to take care of that. Okay, let's see. Oh, and importantly, if your homeowner's insurance is not being paid through your escrow account, it is really important that you keep the insurance current, even if you're not able to make the payments on the home. The reason being is, you know, the mortgage is a separate legal responsibility from being the land owner according to the county records. So if you don't keep your insurance current and someone gets hurt on the property, they're not going to sue the bank who's in the midst of foreclosing on the home. They're going to sue you because you're still the property owner. So it's very important that you keep the insurance current. The next question is, where can you get information on the status of your foreclosure? Well, that's very simple. You can actually go to the county, Clark County Recorder. If you Google that or put that into a search engine, you'll come up with the county recorder's page, and then you just do a property search. You can search by owner name. If you own several properties, just make sure it's the correct property that you're looking at. A way to determine that is you go to the Clark County Assessor's page. You can plug in the address of your property, and it will give you in that printout an APN number. APN number is how the Clark County Recorder provides information about the status of a parcel. They do not use actual addresses on the recorder's page, but between the assessor's page and the recorder's page, you can get that information. Okay, next question. Let's see. Okay, I've applied for a loan modification. Should I be concerned about foreclosure? The answer to that question is yes. Even if you have applied for a loan modification, it's quite possible that the lender will continue the foreclosure action on the property. The reason being, a lot of times people aren't approved for a loan modification, or they don't adhere to the terms of the loan modification, and the banks do not want to stall the process of the foreclosure any more than it probably already has been. The only exception to that is if you apply for HAMP, which is the government-based program for loan modifications. If you apply for HAMP, the HAMP guidelines state that the bank cannot proceed with a foreclosure sale or refer a property for foreclosure if you have applied for HAMP until and unless you get either an acceptance or a denial of a HAMP trial modification program. If you're approved for HAMP and the lender lets you know that you've received a trial offer, so long as you accept that offer, then the foreclosure won't go forward. If you don't accept the trial plan, or if you're denied, then the foreclosure will be reinstated. And many times with clients where we're trying to get a loan modification and they're still trying to notice the sale of the home and move forward with the foreclosure process, we oftentimes are communicating with the bank and letting them know that HAMP doesn't allow them to continue and pursue a foreclosure when we still don't have a HAMP determination on the loan. Okay, next question. This is a good one. If my landlord isn't paying the mortgage, then I don't have to pay rent. Wrong. So all of you out there that are renters, your contract with the landlord to pay rent is separate from the landlord's contract with the bank to pay on the loan. Now, common sense, that doesn't seem fair, it doesn't seem right, it doesn't seem plausible. However, the Justice Court judges have evicted tenants who have refused to pay rent even when their landlord isn't paying the mortgage. Now, if the landlord isn't paying the mortgage and they're collecting rent from you, they have to give you notice. If they don't, could be perceived as a deceptive trade practice. So you do have recourse against your landlord if they're not paying the mortgage. However, the recourse is not to simply stop paying rent, because then you're in breach of your rental agreement. I highly recommend anyone who suspects that the mortgage of the property they're living in isn't being paid to determine and contact the landlord and find out what their intent is. It could be they're getting a modification, in which point there's no risk of you having to move out. If the sale goes forward and you're a tenant, you have by right a 90-day provision to stay in the home past the foreclosure. However, you have to continue to pay the new landlord rent. If the new landlord does not accept the rent, then you should put it in an escrow and at least show an attempt to make that payment. But you can't just stay for 90 days without paying rent. So that's some of the different myths that are out there. And the landlord-tenant component to the foreclosure has been a very complex area. The Nevada legislature has addressed it, but moreover, the federal legislature has really come forward with some strong legislation that protects the tenants. So if you are a tenant and you want to enforce the contract and you want to stay in the home and continue to pay rent, it's probably worth a consult with an attorney for your specific situation to help you educate the new landlord. A lot of times they're sophisticated real estate professionals that are buying these foreclosed homes, and they know what the rules are and what the rules aren't. But we do have a lot of people that are buying homes at foreclosure that don't know the rules. And in those scenarios, that's where a lot of the conflict arises. And sometimes they think that they can simply come and change the locks, which you cannot do. Even after a foreclosure sale, the bank cannot just come and change the locks on the property. There has to be a proper lawful eviction, and landlords cannot use self-help to evict a tenant. You have to have the court's assistance. Okay. So we're going to talk about a couple of the top 5 facts and fiction with regard to foreclosure. For the fiction categories, the top 5 myths that we hear a lot and a lot of people ask us about. Number 5 is that foreclosure is better than bankruptcy. That is an absolute myth, and is not a definitive one way or the other. Sometimes foreclosure would be better for an individual. Sometimes bankruptcy would be better for an individual. But that myth that foreclosure is better is not correct. Many loan officers actually will prefer to see a bankruptcy on someone's credit report as opposed to a foreclosure, because there's no concern going forward in time, if they were to loan you money for another house in the future, that there's a potential lien following you from that foreclosure or litigation from that foreclosure. So with regard to being loan worthy in the future, bankruptcy oftentimes is better than a foreclosure as far as how it appears to a lender with regard to their risk. As far as credit score damage, there's not much difference between a foreclosure and a bankruptcy. It's usually the conduct and behavior of the debtor leading up to the point of either a foreclosure or bankruptcy that damages the credit score. If you